My lords, I just wanted to pick up two points in respect of my learned friend's skeleton. So he has, since that's my response before he's able to deal with those.
Yes.
First of all, in terms of paragraph 8, reference to the witness statement of Miss Carpenter, who's one of the council's policy officers, as the learned judge said, what is said by the council's officers as the intention behind the policy is not an aid to its interpretation. It's not something which the public or somebody reading it will have.
Just not admissible.
Sorry, Lord?
Just not admissible.
That's correct, my Lord. May provide put in evidence which there was, but it doesn't help my interpretation. My learned friend then, paragraph 10, refers to G7 of the London Plan, and we can turn that up, which is in bundle C, page 338.
Could you just give me that one, sir?
338, my lord.
Thank you.
And firstly, the London Plan isn't, as the learned judge below ultimately recognised, an aid to construction of the local plan. The two documents are not required to say exactly the same thing.
Is that so, notwithstanding the cross-reference to it in both in the text and in the paragraph G?
Yes, that's simply the cross-reference is the reference to the mechanisms for calculating compensation, I-tree or cavat. We do have some of the documentation on cavat in the papers.
Yes, you're saying that doesn't open the door to the use of G7 as an interpretive tool for the interpretation of Q10.
Yes, Mother, it doesn't open it up, and also, of course, G7C is expressed differently. The first sentence, which is the one that has some relationship with Q10B and C1, the development proposal should ensure that wherever possible, existing trees of value are retained. So the London Plan policy puts into the retention part of it an exception in those terms. If you are going to, it simply illustrates the point, if you are going to qualify B and C1 in Q10, then that qualification would either be within that or expressly cross-reference if it's done elsewhere. It's not qualified by a side wind by the opening words.
You can have the same argument there, can't you? Because you can always build around a tree. You just may not get the benefits that you're trying to get by a particular scheme.
Yes, you can. Well, maybe some exceptions depending on the size of the plot you're dealing with, but often the outcome is going to be.
That's the stuff of argument.
That becomes a stuff of argument. That's not what we're concerned with here. But has an element of wherever possible in that does have an element of, well, what actually development you're getting out of the process, and that perhaps that debate of judgment, to what extent.
But I'm sorry to labour this point, but I'm just not sure that I feel I've got to the bottom. As soon as you introduce a concept of necessary or imperative or possible, you're bound to have some form of balancing exercise, aren't you? Once you acknowledge that it's always possible to leave a tree where it is.
Well, if the question is whether the removal of the tree is necessary, it's necessary for what necessary for the application, which is made, so necessary for the scheme. That's not a balance between, which is the exercise which would be done, and the exercise that's looked at in February, balance between the benefits of the scheme and against the value and consequence of the loss of the tree. But it's asking the question, well, if we go ahead with this scheme, do we need to lose the tree? That's as far as a concept of necessity, or in this policy, imperative lies. And that interpretation of that is consistent with the rest of Q10, a balancing exercise within G, which takes account the value of the tree, in a way which gives significant weight to valuable trees, but is simply puts them in a balance, is an exercise that's contrary to B and C1, which don't admit of a balance within the policy. It's whether or not you lose the tree.
That takes us back to the submissions you've...
That's good. My Lord, that's perhaps the sort of the fundamental point. We read the policy in its ordinary language. The hope with policies is that the reader is able to understand what they are saying and understand how to apply them without having to go into extensive analysis and debate about what the policy means. And reading this policy in its ordinary context, B1 and C1 are unqualified. They put a prohibition. G requires compensation if it's necessary to lose any tree in that process, but it doesn't have a balancing exercise which allows you to downgrade B and C1 from their simple, straightforward meaning, which is the policy is that those trees should be retained. The council can choose not to follow the policy on the basis that it's outweighed and that material considerations outweigh the harm to the development plan from that. But that's not the exercise which the council went through in the November decision. And in doing so, they fell into error. They fell into error because of their misinterpretation of policy Q10. My lords, unless I can help any further, those are all my submissions in opening.
Right, thank you. Thank you very much, Mr. Bond. Yes. Thank you very much. Yes, Mr. Reid.
Thank you very much, my Lord. I'm going to deal with 5 areas, if I may, in terms of my submission. First of which I'll deal with relates to the wording itself of the relevant policy. The second point is dealing with the consistency of the Council's interpretation with both the London Plan and national policy. And my position on that is that it is an aid to, they are both aids to the interpretation of policy Q10. The third area relates to the practical consequences to decision making if the appellant's interpretation is adopted.
Yes.
The fourth area deals with a particular consequence of the appellant's argument insofar as it's suggested that the significance of particular trees can't be taken into account under paragraph G. So I'll address that. Essentially related to the question as to whether or not significance of a tree is capable of being accommodated the last area concerns the realism that the council's interpretation has in comparison to the appellant's approach. So can I deal firstly then with the wording of the policy, and I've essentially got 4 points under this heading. Yeah. And I accept that paragraphs B and C are largely in absolute terms requiring retention, albeit that there are some caveats within paragraph C, particular aspects of the nature of the retention in question. But I, perhaps unsurprisingly, asked my lords to consider the point in paragraph G, which is that it acts, at least in terms of its wording, as importing a conditionality somewhere within the policy, using the word where it is imperative, stress where in that context. So simply on a standard reading, or a natural reading of that phrase, it would import conditionality.
Yeah.
Second point is that the policy is not simply saying where or if trees are removed, then there needs to be adequate replacement. What it's saying is that there is a necessity for, or rather it is imperative for the trees to be removed. Which means that if one's trying to understand the wording of paragraph G, it is plainly importing some significance in relation to the conditionality. Don't use a word like imperative in simple terms, unless you mean something by it. Now, before I come on to...
So what you say does mean?
Well, I say that imperative means of overriding importance or essential. Now,
essential to enable this application to proceed?
Essential, not simply functionally, but when one's using the phrase essential, particularly in a planning context, one would look at the importance or the significance of the subject matter that one is dealing with. So that would necessarily incorporate not simply a question as to whether or not something can be removed or is required to be removed, but what actually is being removed, and is that justified?
So it's bringing in a whole alternative test, conditionality test.
It is mine.
As an exception to BNC.
Correct.
Well, it introduces on your submission planning considerations that are of overriding importance or essential character, if you like, or quality, to justify what is done.
That's right. And I'll come on to the other factors that indicate that interpretation is correct. But the alternative interpretation, the essence of the appellant's interpretation, is that it simply means if the trees are in the way. And as my Lord Justice Smith said, there will always be a situation in those circumstances that the trees will be capable of not being removed, because you can design a building in ways that there's no need to remove it. So that one must ultimately be undertaking some sort of balance when one's considering the question as to whether or not a tree should be removed in imperative terms. And I do say that the way the appellant put its case fluctuated during the submissions, in that Mr. Harwood suggested that yes, imperative means something, without actually defining what it meant, but then returned ultimately to the position that he took in his skeleton, which was that it really means in the way. And if it is in the way, then it engages that test and compensation has to be made.
How do we get that imperative is a sort of planning, balancing exercise?
Well, firstly, that imperative means something significant one doesn't use the word like imperative just in broad terms or in without actually having some significance attached to it. And when one accepts that it has some sort of meaning, then looking at it in the context of the overall structure of the policy, which is indicating that there are absolute element or absolute terms in it requiring retention, then the significance bites on that question of retention and requires then consideration of the wider issues.
So how is the imperative nature of B and C not and only C1 reflected then in G? The absolute nature of B not be permitted and only where have been retained.
Well, because what it's saying is that where it's justified or where it is imperative, using that different word, or where it's of overriding importance, then in those circumstances there won't be a contravention of the policy, but you still have to make compensation in accordance with the calculation.
What then is the purpose of writing B and C in absolute terms?
Well, one needs to understand, and I of course accept that one needs to read the policy in the terms that it has at the moment. But the policy derived from an earlier policy that was in absolute terms, and one can see that G was simply added in.
Yes, but B and C still haven't been changed. They're still in absolute terms.
They are still there.
So why leave them in absolute terms if actually they're not? They're just conditional.
Well, because you still start from the position that development will not be permitted if you don't pass the threshold of G.
Is it a default? Are B and C effectively a default position?
Well, they're rather than a default, they're an initial position as to what would be the situation if you can't establish imperative circumstances. G allows you to do that. So that if, for example, there isn't any particular benefit associated with the development in question, that you can pray in aid to even get close to the paragraph G exemption, then you apply B and C.
Imperative is quite an odd word to use, confined to removing trees, because you're saying it has this rather large structure placed on it, which is to bring in a very significant balancing exercise that goes beyond the simple fact of removing trees to looking at the benefits, the planning gains, the housing gains, the environmental aspects, the social aspects. It's a massive amount riding on imperative to remove trees.
My Lord, in one sense it is, but actually in the context of the planning system it isn't, because as my Lords have observed, there will be a need to take into account those various material considerations outside of the policy and that actually aren't engaged by way of the development plan at all. So the imputation of those issues within the body of the policy is one that actually provides a comprehensive structure for the consideration of trees generally.
Could I just postulate something which is not, I'm not saying it's this case at all, I'm simply taking a hypothetical example for the purposes of my question. If you have a situation where the borough has its 5-year supply of housing land, ample supply of affordable housing, that it's done everything that policy requires of it in that regard, and a developer comes along with a housing scheme and says, I'm going to build houses here. This is the layout, and as you'll see, I'm going to be taking out this tree, that tree, and the other tree, because that's where I've chosen to put unit number 3. And it's demonstrable that you could have moved unit number 3 across or taken it out and had one fewer dwelling. That might be one situation, but another situation would be where there is a parlous shortage of housing and affordable housing, and the developer comes along and says, I appreciate that this will involve some loss of trees, but I'm making a very significant contribution to meeting housing need and affordable housing need in the borough. And I claim for that consideration the status of an imperative factor weighing under paragraph G in favour of the removal of two or three or four significant trees. Those are different situations. There's a planning judgment to be made inherent in the application, whatever paragraph G means. Presumably there is a planning judgment inherent in that word imperative. And you're saying that actually the way to take a wider understanding of that is not in any way to make the policy laxer. Is that right?
That's right. That's right. One requires consideration of all of those elements that might positively favour the removal of the tree when reaching a conclusion as to whether the initial prohibition should be overridden. And as I say, that's in accordance with the overarching point that's made by Mr. Harwood on behalf of the appellant, to the effect that, well, all of those considerations will have to be taken into account, which is outside of that policy.
Yes.
Which just doesn't make sense of having make sense of a policy whose specific focus is on a particular issue in question.
I mean, if the policy had said imperative in the sense of there being no alternative siting of the buildings in question, but to remove the trees in that place, you say that would be a different policy?
Yes, I do. The way the appellant really is putting its case is that it just means in the way, and then one pays compensation. But that just does a violence to the word imperative, which patently has some greater meaning, and an interpretation that is in accordance with the general approach towards material considerations is one that actually is a reflection of the planning system, not contrary to it. Well, those are the 4 points that I was going to make on the wording. Unless
I've got 5, but there we are.
It may well be that it was 5. I think it's probably more. I confess to having
But it really comes down to your last formulation, which is imperative has a wider meaning than in the way.
Yes.
Simply physically in the way.
Yes.
Because reading the judgment below, there's almost a suggestion that what was being submitted was, unless the tree occupies the physical state where building is going to happen. So not a wider thing of preventing this scheme being built. But was that really what was being advanced below? You've got to have your tree where you want to put a spade in the ground. Was that correctly understood by the judge below?
Well, the court below observed that, or took the position that one will necessarily be considering whether or not it's in the way, because of course it won't engage G unless it is proposed for removal. And when one's looking at it in the context of that, but it's simply whether or not that's all it means, or whether it imports some wider set of factors.
I think you're submitting that it's an objective test which engages planning judgment, not a subjective test at the whim of the developer.
Absolutely.
Or the whim or choice. That's the developer.
But I reiterate, my lord, that those various factors are ones that would be the material considerations that Mr. Harwood says would be taken into account in any event. Well, may I go on then to my second area, which concerns the consistency of the Council's interpretation with the London Plan and national policy. My lord, as my lords have already seen policy G7, but it's at page 338 in the core bundle. In fear of repeating those submissions that have already been made, the first sentence deals with the relevant exception, which is wherever possible.
Sorry, the page?
The page 338 of the bundle.
Yep, sorry.
I asked my lords firstly just to note that particular aspect of the policy. It then goes on to the second line: if planning permission is granted that necessitates the removal of trees, there should be adequate replacement based on, and then it identifies the caveat requirement. But the initial engagement is if wherever possible, and that's reflected actually in the national policy position as well that I'll come on to. But that necessarily imports a requirement to consider the wider factors beyond the simple functional question as to whether or not the proposal will have the effect of removing a tree. And I don't understand the appellant to be saying anything else. The appellant's point on G7 is that, well, it just can't be used as an aid to construction. But that can't be right in circumstances where policy Q10 itself, as well as the written text, as Lord Justice Limblom indicated, makes specific reference to G7. It shows that the policies work as a suite, in short. And I don't think Ms. Arden was suggesting it, but I don't say that the intention that the Council had in drafting the policy has any relevance in this case. I don't say that. Actually, the reference to Ms. Carpenter's witness statement concerned the fact that caveat as an assessment process will take into account the significance of the tree in question, which I'll come on to in a moment. But I don't suggest that there's any relevance in what the Council was intending by way of its drafting. But when one looks at the fact that it is referred to in the policy, well, it obviously helps to understand how that policy works. And the consequence of that is that G7 is saying one does take into account the wider factors, but on the appellant's case, Q10 says you do not. I present the next section of my submissions by way of that particular submission, and I'll return to that issue in a moment. But I ask my Lord's with regard to the national policy position, that can be found within the extracts of the National Planning Policy Framework, which is it, and I take my Lords directly to the content of the framework. It's page 328 in the bundle. And paragraph 131 is the first. They're disjunctive extracts, so 131, 180 is on the other page. You might all see that, page 329. But I ask my Lords to look at paragraph 131 first. And in the second full sentence of that paragraph, it says this: planning policies and decisions should ensure that new streets are tree-lined, that opportunities are taken to incorporate trees elsewhere in developments, such as parks and community orchards, that appropriate measures are taken in place to secure the long-term maintenance of newly planted trees. And then it says this: and that existing trees are retained wherever possible. That's the first reference. And then the second reference is under paragraph 180, subparagraph C. It says this in relation to those trees that are regarded as irreplaceable habitats, namely ancient woodland, ancient or veteran trees. And my Lords will see what that says. Perhaps I'll give my Lords a moment to read it rather than reading it out. And so For those trees that are of particular value, there will be a requirement for wholly exceptional reasons in order to justify the removal. But what it imports as part of the national policy position, just as paragraph 131 does, is an exceptional situation allowing for the removal of the tree in question. So
imperative is a flexible word, or introduced a flexible test.
Yes.
And it's a higher level of imperative if you're dealing with ancient or veteran trees.
Exactly so. My Lord has anticipated my latest submission. That's the way in which I put it. The framework of the national policy position is to allow for exceptions, taking into account the particular considerations in question, and does so by way of phraseology that is general in its terms. Just like imperative, one uses wherever possible. A broad term, one often sees in a planning context, but that it has the ability to unpack a whole series of factors. So, my Lord, it's perhaps a simple point I come down to in the end, which is that the Council's interpretation is in accordance with and consistent with that national and strategic policy position, whereas the appellant's is out of accord with it.
Yes, the other side says it's an impermissible exercise to do what you've just done. It says that the cross-referencing, to the extent that there is such cross-referencing to G7, is not sufficient to engage a consideration of that strategic policy if you're interpreting Q10. And there's no mention of national policy.
I accept that there's no mention of national policy. With regard to the London plan policy, of course, that's the strategic plan which makes up the development plan for the purposes of the Council's planning area. So anybody who is making any sort of planning application will necessarily have to have regard to the terms of policy G7 when considering trees. So they do, as I say, operate as a suite and must then have the ability to.
Yeah. The other side might say, well, G7 is general and Q10 is particular to Lambeth. And that where you have the particularity of a carefully laid suite of provisions in Q10, it might submit. You don't revert to the generality of G7 to qualify the specific test in paragraph G. It might be submitted. I don't know if that is essentially the submission, but I apprehend it is.
If that is right, it's something that when one's looking at the totality of the development plan, it fails to account for the fact that G7 is in general terms, but has a specific approach towards trees protection, which is to allow for exceptional circumstances for their removal, by way of the phrase wherever possible. The nature of the debate here is only as to whether or not an exception is applicable under Q10. That's right. And all one's taking from G7 is the general principle that, well, that there is an exception.
Right.
Well, that's the second area I wanted to deal with, unless my Lord had any further questions on that issue. The third question, which is interrelated to the second, the third area, which is interrelated to the second area, concerns the consequences of the Council's interpretation, or more significantly, the appellant's interpretation. Because in circumstances where one is dealing with an exceptional case, if it's right that you can't take into account those exceptional reasons under paragraph G for the purposes of Q10, but you can for the purposes of G7, you'll have an accordance with the terms of policy G7, but you will be out of accord with the policy within Q10. And that raises a situation where one's having to reach a judgment as to whether or not a development is in accordance with the development plan, but one has one policy indicator that is subject matter of one is dealing with trees, one policy that's according with the strategic policy, but another policy that isn't. And that is a surprising result and has the potential to lead to confusion, at least in terms of an authority's understanding as to how it deals with the question of compliance with the development plan. Now, I don't put that as a particularly high point in my submissions, but I do say that it does favour an understanding that's consistent with the policy in question, or the policy interpretation that the Council invokes. Well, that's the third point. My fourth point is that the Council's interpretation has the ability to take into account the variable qualities of the trees in question. Because one point, certainly, that was focused upon in my learned friend's skeleton argument was that paragraph G applies to all trees, whereas B and C is specific to significant trees. In fact, C isn't, as my lords have observed, from most areas of respect, it isn't confined to significant trees, but is more general in its application as well. But when one is looking at the question as to whether or not an imperative has been established for the removal of the trees in question, one will consider, as part of that, the significance of the trees in question. So that, as my Lord Justice Moylan observed, the sort of factors that will be taken into account in support of a conclusion as to whether something is imperative will include, or will be affected rather, by the significance of the tree in question. So if they are particularly significant trees, well, the factors that are required to override the existence of those trees need to be that much more weighty.
So where does this point go? Assessment under Q10 will involve assessment of the quality of the trees.
Under paragraph G.
Yes. So
it has a what it will necessarily do by way of an interpretation is accommodate or will address all of the relevant issues when reaching a conclusion as to whether the trees should be removed. One of the points that was made by learned friend Skeleton was to the effect that the Council's interpretation was just applicable to all trees, so it couldn't reflect the particular significance of the trees in question.
I'm being very slow here. So on your interpretation, when considering whether it's within policy, you look at Q10G and say, because you apply all your planning judgments and you conclude that it's imperative and therefore it's within policy.
Yes.
And you say that on the appellant's version, because it's B and C are absolute, you are inevitably outside policy, but then you have to bring back all the same planning assessments to decide whether G is going to require you to secure replacement planting.
Yes, you have to, outside of the policy. You go
outside of the policy. So that's the difference between. But how does that help us decide which interpretation is right?
Well, my submission was really focusing on whether or not the Council's interpretation has the ability to incorporate all of those issues. But I take my Lord's point that
so does his, just comes at a different time.
Yes, Lord, I say that one needs to take a step back and look at this in the context of the planning policy position generally, in the way that I've set it out with regard to G7 and national policy.
Okay, so this is really a subset of your previous point about practical consequences,
It is.
or London plan, your second point about London plan.
Exactly.
Okay, thank you.
And I can go to my last point now, I think, which is the unrealistic approach of the appellants. And I fear that whilst I saw a considerable distinction in writing down my submissions before I delivered them, I confess that perhaps this is a repetition of what I've already submitted, but I will endeavour to make it separate. The appellant's position is, as I say, that essentially one looks only as to whether or not the tree is in the way in order to engage paragraph G. And all of the other factors need to then be considered outside of the terms of the policy. And essentially that does nothing more than put to one side issues which necessarily would be required to be considered under the policy as a matter of generality. And that approach of simply hiving off those various considerations to the assessment outside of the policy is one that doesn't focus on the real way that these decisions are made by planning officers.
Can I just, G applies to all trees.
Yes, ma'am.
So it's saying a tree that isn't within B, you have to decide that it's imperative to remove it. That could include your submission, that it includes general planning policy considerations, because otherwise, what are you balancing it against? But that doesn't mean that it necessarily has to apply to B trees. It's just only applying to trees outside B.
It's applying to, it would apply to all trees, including those that are significant and identified.
No, I understand that, but the fact that this submission is that the appellant's approach is unrealistic, but your approach to G would be perfectly understandable solely by reference to non-B trees.
Yes.
In other words, you still have to decide that it's necessary, imperative to remove it by reference to what other considerations, well, not just it's in the way, but general planning considerations.
Yes. Yes, well, it's broad enough to be able to accommodate both B trees and non-B trees.
I understand that, but it's also constrained enough to apply only to non-B trees.
Yes, certainly. Yes, my order is quite right.
But are you saying that G means that you can't fell any tree unless it's imperative to do so? Or is G simply doing what it appears to say on its face, which is if you've decided that it's imperative to fell a tree, then you must secure replacement planting?
No, G requires, will be considered and will, the imperative nature or the establishment of imperative factors must be applied irrespective of the tree in question.
Right, so I think really you're saying that G itself imposes something which is very close to B and C, because if a tree is not within B and C, then how is it going to be said to be imperative to fell it?
Well, there will be various factors that would, it may be a non-significant tree, and it's being proposed for removal.
Mm-hmm.
One would then still need to consider all of the relevant factors, but against the context of it not being a significant tree under the BS categorisation.
But I think you are accepting the proposition I was putting to you, which is that on that interpretation, G is itself acting not merely as an exception to B and C, but as a freestanding requirement that you can't fell any tree unless it satisfies unless it's imperative to do so.
That's right.
And you say that's reasonable because of the overriding view reflected by A, B, and C.
Yes.
And in fact D, E, and F.
I do, and reflected in national policy and in strategic policy.
It's a pretty strange way of introducing a new general criterion, isn't it?
Well, my lord, not if one understands the import of imperative or the significance of imperative as meaning something. It can't but mean, in my submission, effectively wherever possible. Or
well, the simple thing would be to say no tree shall be felled unless it is imperative to do so. Full stop. Next paragraph. Where it is imperative to do so, you shall secure replanting. Full stop.
I entirely accept it could have been written in that way. But, as I say, imperative has to mean something.
What the reader of the policy knows is the policy says what it says. What the reader of the policy does not know, and is not presumed to know, is its drafting history.
I accept that.
So we, the court, have to make the best of the policy as it is written in interpreting it.
Yes.
Your submission is effectively, I think, that paragraph G has the effect, among other things, of qualifying B and C to the extent that it introduces a path to acceptability through the test of what is imperative.
That's right, man. That is what I say. But I also say, if I may add to that, that if one is looking at the Tesco and Dundee test, reading objectively the words of a particular policy in its proper context, that proper context is the planning context that I've already said.
Yes, I mean that's obviously part of your submission. But the core submission in your case is that paragraph G has the effect of qualifying paragraph B and C. And you say that is a realistic approach, as it turns out, consistent with both London Plan and national policy.
Yes,
Right. Yes.
my lord, those are my submissions. Unless my lords have any questions.
No, thank you. Thank you very much.
My lord, just a few points, I hope. To pick up on my lord, the senior president's last sort of comment, that's the critical point. The council's interpretation below, has to rely on the opening words of paragraph G, qualifying the absolute words of B and C1. And my lords, on an ordinary reading, they do not do so. Policy is something which should be hopefully understood without having to spend half a day in the Court of Appeal poring over it and making it complicated and putting excessive reliance and weight and heavy lifting in a particular word. But B and C1 are not qualified. I'll come on to G in a moment, but to take, of course, the points in context, the purpose of the policies is to set out what the local authority considers to be acceptable in planning terms. In applying the policies, there will be sometimes a degree of judgment about whether the policy is complied with, but also there will be an overall balance exercise to be done if there is non-compliance with the policy, but it's recognised by the need to have regard to the development plan, to make decisions in accordance with the plan as material consideration indicate otherwise, that policies are there to set what the approaches are. Policies might not be complied with. There may be sufficiently good reasons for not complying with the policy. But having policies which are clear and policies which may be put in absolute terms is entirely permissible, and in a sense is often the desirable way of doing it, rather than having a policy which contains a vague and unexplained balance within it. A balance can be set out in a policy if the decision maker wants to do it, but the decision maker will write it to do so. This policy does not contain a balance. My learned friend referred to the national policy and to London Plan, but in both cases they're concerned with retention wherever possible. That's how you would write a balance in. What we have in this case is the local authority relying on the change in G to, on the one hand, increase protection to trees which are not of significant value, because ourselves and the local authority are in agreement, and seems to be the view below, that G, of course, does apply to all trees. It refers to it being imperative, the trees being lost, and that then imposes, in respect of all trees, a question of the non-significant trees, a question of whether there is a need for the loss of the trees. So it widens protection for those non-significant trees. What it does not do is to do what the council asserts, that it weakens protection for the significant trees. The absolute nature of B and C1 remains. And in terms of the argument to weaken protection, my learned friend needs to put an awful lot into imperative. That it ranges from the non-significant trees up to, on my learned friend's analysis, the question of whether there should be a loss of ancient or veteran trees, at which level the national test is one of wholly exceptional. In terms of significant trees, in terms of the policy, we go back to what the policy says straightforwardly, and that straightforwardly is in B and C1. That creates no particular difficulties. It's the same, B and C1 are the same as they were in the 2015 policy. If the London Plan, in some cases, pushes in a slightly different direction, then so be it. The authority has to weigh that up. But the authority should apply B and C1. It would need to acknowledge that a proposal for loss of significant trees, as was the case here, is contrary to B and C1. The authority, in its report in November and in its submission, never makes that acknowledgement. If the scheme is contrary to B and C1, but the authority were to take a view at looking at all the impacts, including all the heritage harm and so on, that the scheme should proceed, then paragraph G applies to require compensation to be provided in accordance with its provisions. And that is a perfectly straightforward application of G. What it doesn't do is to set aside, or to use my Lord's expression, qualify. And it's an important qualification. It doesn't qualify the absolute language of B and C1. That is an error in the Council's approach in the report in November, which they did not appreciate, that there was that breach. G does not change that part of the policy, and what we have in terms of Moylan and Friends arguments are putting too much on the opening words of a paragraph which is principally a confrontation provision, and that as a mechanism to undermine the clear understanding of the policy which a reader would gauge. That is an over technical and wrong interpretation of the policy. If the council policy was a qualified approach to trees of significant value, then that qualification could be set out clearly that a qualification is not there. The approach is unqualified. Protection of those trees can be overcome, but it needs to be overcome in a lawful fashion, correctly understanding the policy, and that has not happened in this case. My lords, unless I can help any further, those are all my submissions.
Thank you very much.
Right, my lord.
Well, we're very grateful to all council, those who have made submissions in court as well as in writing, and also the advocate who's made submissions in writing only. Very grateful for the clarity and conciseness of those submissions. We're going to reflect upon them, reserve our judgments, which will mean that in due course we shall circulate a draft of our judgments for typographical minor factual errors to be corrected in the normal way, a draft order to be agreed, and a date for hand down set at that stage. The arrangements for hand down, as you will be aware, nowadays do not normally require the attendance of council or others at that point. That is how we shall proceed. Thank you very much.
All rise.